Section 7 of the Act relates to devolution of property in South Indian families, and those families are joint families and they are known as Tarwad, Taviz, Ilom, Kutumba, Kavaru, and Satnam. So these families, and regarding the very devolution of property or the interest in the property of these joint families were governed by Maruma Kattayam law or the Namrudi law as per subsection 1 of the Act. It provides that the devolution of interest in such joint families' properties under this Act no more is governed according to the Maruma Kattayam or Namrudi law. While Marumu Kattayam is a body of customary laws followed by the Brahmins in Travancore, Cochin, and Malabar, and regarding subsection 2, and that relates to alias Satanam law in South Kerala, and regarding that subsection 2 of section 7 deals with devolution of interest in the property under this Act, not according to the earlier Santanam law, which is a customary body of laws followed in South Kerala. So the above three customary laws provide that inheritance is based on Maitreya Chati, that is, the members trace their descents through a common female ancestress or through female lines. And as regarding Tharwad, it is a joint family and its very character is matriarchal in nature and also matrilineal in content, and it also matrilocal. And Taviz is a branch of Tarwad, and Kavaru or Ilium are the branches of Tarwad and they are equal to Taviz. And regarding Kutumba, it is the Tarwad or the joint family, and it was prevailing in South India and it was being governed under those laws like the Marumu Kattayam law or Namrudi law and the alias Santanam law in South Kerala. But under subsection 1 and subsection 2 of section 7, these were no more applicable regarding devolution of interest in property in those families. So, subsection 3 of section 7 that deals regarding Satnam property and the very devolution of interest in the Satnam property on the death of a Satnam Dhar, and Professor Moore in his Malabar law defined Satnam as a station or a rank or a dignity, the holder of which would be known as Satani or Satnamdar, according to the local custom that was prevailing in South India. So now we'll discuss regarding section 8, which deals with classes of legal hair. So regarding that, it provides four classes of legal hairs, such as relatives in class 1, relatives in class 2, the agnates, and the fourth one, the cognates. So, the legal hairs of a male Hindu who dies intact, and they are falling under these four categories. The words dying instead means when a male Hindu dies instead, not having made any will or having made an invalid will. The Act does not govern succession to the property of a male Hindu whose death took place before the commencement of this Act, and Section 9 of the Act provides regarding order of succession both in class 1 and class 2. And in class 1, the very order of succession is governed simultaneously with an equal share to all the legal heirs. And regarding class 2 legal heirs, the rule of preference is applied. So this section provides the order of succession in class 1 and class 2 of the schedule. The relatives mentioned in class 1 of the schedule succeed or inherit simultaneously and with an equal share. But in case of class 2 of the schedule, the rule of preference is applicable. This means the heirs in first entry shall be preferred to the second entry, and those in the second entry shall be preferred to those in third entry, and so on in succession. So, the very line of succession which we like to discuss are the son here includes natural son, posthumous son, and adopted son, but exclude illegitimate son and stepson. And here daughter means married or unmarried natural daughter, adopted daughter, and also posthumous daughter. But it excludes illegitimate daughter. And here mother includes adoptive mother, but stepmother is not entitled to the very succession or to the order of succession. And the list besides the above, it includes the widow of a predeceased son or son of a predeceased daughter or daughter of a predeceased son, also daughter of a predeceased daughter, daughter of a predeceased son of a predeceased son, as the other legal heirs. The widow of a male Hindu cannot be divested of from inheritance on the grounds of conversion, remarriage, or unchastity, but widow of a predeceased son and widow of a predeceased son of a predeceased son are disentitled to succeed in case of remarriage. Mother of the deceased cannot be excluded on the grounds of unchastity or remarriage. And in our next upcoming video, we would like to discuss regarding section 10, which deals on rules on distribution of property among the legal heirs falling under class 1 of the schedule.